We'll talk about this. Former prosecutor Donald Schweitzer and criminal defense attorneys John Patrick Dolan, Bernie Graham, and Michael Cardoza. Well, John, would you subpoena if, in fact, Macaulay Culkin is not going to volunteer? Would you, as a defense attorney, subpoena him, try to get him in there to repeat what he said, certainly on television?
Sure, I would, and I'd subpoena every other kid that wasn't called. But let me tell you the real problem here, Catherine. Let's suppose they get a conviction. Every one of these 1108 scenarios is going to be evaluated by an appellate court. Unless they make special findings on each one, if any one doesn't pass the smell test on what they call 352 in California, the probative value outweighing the prejudicial effect, they've ruined their conviction. And I think that's the murky problem here that the prosecution has created, and it's going to be a problem in the future if they get a conviction. And boy, that's looking more probable the more this evidence comes on.
Let me ask Donald about that. Let's get the prosecutor's point of view, because this statute is very tricky. Most people say this will be the movement into the appellate courts and very likely reverse the case.
You know, 1108 has been analyzed a lot during the past 8 years. If you go in and you read the decisions with respect to this statute, it's been tested. And I don't believe for one second that the judge in this case is going to make any error with respect to the jury instructions. I just don't think it's going to happen. Thus far, it's been extremely good evidence for the prosecution. A lot of people may debate whether it should have come in at all, but I don't believe there's going to be an instructional error. And especially with our colleague, Mr. Dolan, giving us further education, the judge is probably going to even know to do it now. So thanks, James.
Well, Donald, will they have to make a specific finding as to, do you agree that each one of those, that there has the propensity evidence, they have to make a finding about in the verdict form?
I don't believe that it has. In the cases that I've tried, I haven't seen that necessity. You know, maybe Mr. Dolan knows of something that I don't, but when I tried these cases, that wasn't done.
Well, can I say something about that, Catherine?
Absolutely.
Here's the problem. If you don't make special findings, let's suppose that an appellate court says, look, you had 6 scenarios of 1108 prior bad acts, but one of the 6 really shouldn't have been admitted. That's a reversible error. The only way to solve that problem is to make special findings on each one. And I don't think the judge is going to do that. So it's just a mess.
Oh, dear.
Well, keep in mind,
Colleague here.
Go ahead.
3 things they have to do on the defense as a person who's tried these cases. You do put on these boys if they're available. You do call Michael Jackson to the witness stand, and you do put on every celebrity character witness you can get a hold of. That's the basis of the defense in this case.
I have no problems with character witnesses. I mean, that's one thing that's got to be done by Mesereau, and it's going to really help Jackson. But if you're going to be putting on prior victims and try to disprove acts, you know, the cat's already out of the bag. People already know that Jackson has this fetish. You know, you just don't spend that much time on it.
Yeah, Michael, what do you think?